It's my privilege to welcome you today to the William R. Stewart Memorial Lecture for Labor and Employment Law. Established in 2006, this lecture honors the late Bill Stewart, who was one of our distinguished graduates. He was a veteran of the U.S. Army. He earned his J.D. here in 1959, and 40 years later was inducted to the Academy of Law Alumni Fellows, which is the highest honor the law school can bestow upon any of its graduates. For 34 years, he was a lawyer with the National Labor Relations Board and was the board's first African-American chief counsel. His leadership and commitment to excellence prompted President Bill Clinton to award him the President's Award for Distinguished Federal Civilian Service and to characterize his contributions to the NLRB as unparalleled. At the time, he was the first and only NLRB employee in its entire 69-year history to receive this honor, the highest honor that any civil servant can receive. The Stewart Lecture is just one way that the law school seeks to introduce its students to interesting issues in employment discrimination, labor and employment law, from Professor Ken Dow-Schmidt's innovative and I would call ever entertaining, at least from a dean's perspective, labor law course, to Professor Whitus's cutting-edge scholarship in the area of pregnancy discrimination, to Professor Weng's disability rights clinic and work on the veterans' rights area, to speakers and events sponsored by our student organizations, to students who regularly participate in the Peggy Browning Fellowship, working in organizations such as the AFL-CIO, to last year's hosting of the annual colloquium and scholarship in employment and labor law. Past Stewart lectures have included some of the most prominent labor and employment scholars in the nation. They include William Gold from Stanford University, Laura Cooper from the University of Minnesota, Martin Malin from Chicago-Kent, Matthew Finken from the University of Illinois, and last year Paul Secunda from Marquette Law School. This year, we're incredibly pleased and privileged that Sam Bagenstos is joining us to give the 2016 Stewart Lecture. Professor Bagenstos is the Frank G. Millard Professor of Law at the University of Michigan Law School, where he specializes in constitutional and civil rights litigation. From 2009 to 2011, he served in the United States Department of Justice, where he was the Principal Deputy Attorney General for Civil Rights, the number 2 official in the Civil Rights Division. His accomplishments there include the promulgation of the 2010 American with Disabilities Act regulations, the first comprehensive update of those regulations since they were first promulgated. A prolific scholar, he has published dozens of articles in the nation's top law reviews and is the author of 2 leading books in the area of disability law and the disability rights movement. In addition to his scholarship, he remains active as a Supreme Court litigator, having argued several cases before the United States Supreme Court. In addition to Michigan, he has served on the faculties of Washington University School of Law, Harvard Law School, and UCLA Law School. And before entering academia, he clerked for Judge Reinhardt of the Ninth Circuit, Justice Ginsburg of the United States Supreme Court, and worked in the Civil Rights Division of the United States Department of Justice. He holds a J.D. magna cum laude from Harvard, where he received the Fay Diploma and the Sears Prize. He received his B.A. with the highest honors and highest distinction from the University of North Carolina. Once again, I feel like I have wasted my entire life. Please join me again in welcoming Professor Bagenstos to the lecture.
So I really appreciate the introduction. I always think the introduction is the best part of the talk. So it's all downhill from here. For me, maybe not. Probably for you too, unfortunately. And I'm really very honored to be invited here to give this lecture, I will say, both because of who this lecture honors, who's obviously such a distinguished graduate of this law school, but also because of the many incredibly distinguished people who have come before me giving this lecture. This is sort of the premier lecture on labor law issues in America, and I was sort of shocked and surprised and incredibly pleased to be invited to do it. So what I'm going to do, I am not a person who does a great job standing behind a podium and reading a text. Nonetheless, I sort of feel that an academic lecture deserves that, and so you're going to see me at war with myself through this entire talk, and I will see what happens. It'll just be a test for me. What I want to talk about, the title of my talk is Disability Rights and Labor. Is this conflict really necessary? Kind of bringing together a couple of interests of mine, long-standing interests of mine, and pulling out some of my own experiences, but also trying to make both tell a story and make a normative argument about what should happen. So I'll just kind of launch into it, and I look forward to hearing your reactions to it. And for those who are watching on the camera, so I can tell you can probably, it looks like an empty room because all of the seats actually sort of in a cone coming from the camera out are empty. There are a decent number of people here, so which I attribute to the quality of the food and not to me. But in any event, so I guess I'll start with this is an example of the relationship between the American labor movement and identity-based social movements in America. And it's a relationship that has forever been a complicated relationship. So we know organized labor has often been an ally of civil rights struggles. We know that many civil rights leaders have often supported the claims and the campaigns of organized labor, right? We know this in part based on the way it's best exemplified by the reason Martin Luther King was in Memphis on the day he was assassinated. He was lending his support to a strike by unionized sanitation workers. But it's also true that unions and civil rights groups have found themselves on the opposite sides of intense battles as well. These battles have included fights over race and sex discrimination and harassment in union-dominated workplaces, which often pitted civil rights groups against the public safety worker and craft unions that themselves often had a history of discrimination, and struggles over sex-specific protective labor legislation, which was supported by a wide swath of the labor movement, but in the end severely limited job opportunities for women. And what I want to talk about is the relationship between the labor movement and the disability rights movement, which has been just as complicated. Organized labor has often been an ally of disability rights efforts, but in some of the highest stakes battles for workers and individuals with disabilities, unions and disability rights groups have opposed each other. Many commentators before have written about the tensions between labor unions and civil rights groups promoting sex or race equality, but there's been very little exploration of the similar dynamics of the relationship between unions and disability rights groups. And this is a good time to talk about that because in the past several years, the tensions in the labor-disability relationship have been especially acute. As unions, particularly the SEIU, the Service Employees International Union, have pushed for increased wages and benefits for direct care workers who provide home and community-based services to people with disabilities, and state Medicaid cuts have placed pressure on the budgets available to pay those workers, many disability rights advocates have worried that labor's agenda will lead to the reinstitutionalization of people with disabilities. This is a tension that stood in the background of the litigation in Harris v. Quinn, in which the Supreme Court addressed the collective bargaining system some states had set up for personal assistance workers, and the dispute between unions and some disability rights groups came out in a particularly sharp and nasty way in response to the Department of Labor's recent rules expanding Fair Labor Standards Act protections for home care workers. Although some disability rights groups supported the new rules, which had been a major priority of organized labor for years, there were particularly vocal and influential activist groups who opposed them, to the point, and this is true, I thought of this being my one visual aid, to the point of sending lumps of coal to the house of the Secretary of Labor at Christmas and conducting sit-ins at his driveway. Because they were opposing labor protections for workers who provide direct care services. So these, I want to say, are not something new in the disability-labor relationship. Disability rights activists have long challenged the paternalism of those assigned to help, scare quotes, or care, again, scare quotes for them, and the unions that represent those workers are thus a natural target for suspicion, if not antagonism, and many, though not all, elements of the American labor movement have strongly opposed the deinstitutionalization of people with mental disabilities. And the current labor disability tensions can't be understood outside of the context of that history. So what I want to do in this lecture is two things. One, I want to put the current labor disability controversy into that broader context. And second, what I want to do is at least begin to sketch out a position on how disability rights advocates should approach both these current controversies and labor disability tensions more broadly. So as to the narrow dispute over wage and hour protections for personal assistance workers, I argue both that those workers have a compelling normative claim for Fair Labor Standards Act protection, a claim that disability rights advocates should recognize, and that supporting that claim is something that's pragmatically in the best interest of the disability rights movement. As to the broader tensions, I want to argue that disability rights advocates go wrong both normatively and pragmatically in treating the interests of individuals with disabilities as inevitably superordinate to those of the individuals who do the work of providing community-based services and supports. Although this is a completely understandable position in light of the history of paternalist subordination of people with disabilities at the hands of the helping professions, today's situation, I would argue, calls for an accommodation of legitimate claims on each side. And I want to start by noting, you got some sense of this from the Dean's introduction, I'm not offering a view from nowhere. I don't believe in views from nowhere. I don't have a view from nowhere. I've worked in and around the disability rights movement for more than 2 decades. As a lawyer myself, pursuing deinstitutionalization efforts that some unions have opposed, and as a lawyer representing disability rights organizations in some of these very controversies, I've participated in a lot of these discussions and often yelling fights. My argument here takes as a basic premise that the goals of the American disability rights movement, that people with disabilities should have the same opportunity to live in and participate as full members of the broader community as everyone else, that they state a powerful normative claim. I am asking here what stance people who share those goals should take toward the claims of workers who provide services to individuals with disabilities, and I want to argue that even firm disability rights supporters should, in many cases, support the claims of those workers, including in the recent disputes over unionization and Fair Labor Standards Act protection. So let me start by talking about the history of the conflict, and a lot of my talk is going to be about that. So the conflict really starts a long time ago. It starts with the disability rights movement's critique of the so-called helping professions, and then moves on toward the more current controversy. So for many American disability rights activists, the principal engine of disability inequality has been paternalism. Non-disabled individuals, particularly parents and members of the professions, have treated individuals with disabilities as the objects of charity and pity. This is the critique. Although this treatment often stemmed from generous or beneficent impulses, the result was to confine people with disabilities to lives as essentially perpetual sick people, with services designed to care for them rather than promote opportunities for individuals with disabilities to make and realize their own choices about how to live their own lives. And this paternalism was often fed by widespread stereotypes about disability. In particular, one of the things I've written about is that individuals with disabilities, perceptions about individuals with disabilities are marked by what some people call the spread effect, the maybe implicit, maybe unconscious assumption that people who experience limitations on physically performing some tasks or mentally performing some tasks are broadly incompetent to act and choose for themselves. For many disability rights activists, it's these stereotype-driven attitudes combined with social decisions about how to design structures and institutions that in fact are what create disability by making particular physical or mental impairments disabling. And as it came together in the last third of the 20th century, the American disability rights movement devoted much of its effort to countering these stereotypes and to fighting the paternalism of parents and professionals. Movement adherents argued that law and policy should be premised on a social model of disability in which disability is created by these interactions between social choices and physical or mental conditions. And they pushed for policy approaches that would promote independence and integration of people with disabilities. There were approaches that centered on civil rights rather than on charity or medical care. Movement adherents recognized that people with disabilities might rely on services or supports to participate fully in society, but they advocated for service delivery models that would promote independence and integration. In particular, they developed a model of consumer-directed personal assistance services. Under this model, individuals with disabilities who needed assistance with basic activities of daily living would receive that assistance in their own homes, in their communities, from workers whom they could personally hire and fire and whom they could direct on a day-to-day and minute-to-minute basis. Relying on consumer-directed personal assistance, in the view of disability rights advocates, served the independence, right? So it's an interesting idea of independence, served the independence of individuals with disabilities. Those who performed personal assistance work in this view were essentially tools to achieve the ends chosen by the individuals with disabilities themselves. So you see some of the seeds of the conflict. So it's not hard to see how the critique of paternalism and the very concrete effort to shift power from service providers to disabled consumers might have brought disability rights activists into conflict with labor unions that represented professionals who provide services to individuals with disabilities. But the conflict came from the union side as well. So public employee unions, particularly AFSCME, the American Federation of State, County, and Municipal Employees, were the major opponents of disability rights advocates' efforts in the 1970s and the 1980s to end the confinement of people with disabilities in institutions. Deinstitutionalization has been an urgent priority for disability rights activists. You see this in even ADA case law, as Justice Ginsburg explained in her opinion for the Supreme Court interpreting the ADA to prohibit unnecessary institutionalization. She said that confining individuals with disabilities to institutions feeds the stigma attached to disability at the same time that it denies individuals with disabilities the opportunity to participate as full members of the community. And that view has taken hold in the populace at large, or at least in policy at large. Although the number of people with mental disabilities in state-operated institutions has dropped substantially in the past 50 years, 90% in the case of people with developmental and intellectual disabilities, 95% in the case of people with mental illness, there are still thousands of people who remain in those institutions. And thousands more individuals with mental or physical disabilities are institutionalized in state or privately operated nursing homes and other facilities. So deinstitutionalization, although it's been very successful, has remained a centerpiece of disability rights advocacy. And as deinstitutionalization efforts picked up speed in the 1970s, the principal opponents were typically public employee unions, even though those unions had often been responsible for bringing to light the institutional abuses that catalyzed and fed deinstitutionalization litigation in the first place. The opposition of unions to deinstitutionalization shouldn't have been surprising. State-operated institutions for people with disabilities were and have remained heavily unionized, while most of the programs that provide services to the same individuals with disabilities in their homes and communities are not union workplaces. Unions obviously can be expected to fight efforts to shift work from unionized to non-unionized workplaces, and they'd properly be subject to criticism if they didn't. And unions fought deinstitutionalization not simply out of an immediate effort to protect union jobs in institutions. They also feared, and this is really important, the political agenda of deinstitutionalization. Although disability rights advocates believed that institutions should be replaced by robust public services provided in the community, crucial support for deinstitutionalization came from fiscally conservative state politicians. I like to talk about this as the alliance between the ACLU and Ronald Reagan. These politicians sought to use deinstitutionalization as a tool for budget cutting and disinvestment in public services. So efforts at deinstitutionalization threatened both specific union jobs in existing institutions, but also the more general project of public service provision to which public employee unions were committed. So deinstitutionalization thus necessarily stoked suspicion between disability rights advocates and labor unions. And those suspicions haven't gone away. As I note a little bit later, some union and disability rights groups have worked together to find ways of reconciling each other's interests in this area. The SEIU has been particularly forward-looking in doing this, in supporting disability rights while also fighting for the interests of its members. But a strong undercurrent of conflict remains. And in those states that continue to maintain large populations of individuals with disabilities in state-operated institutions, the states that not coincidentally are heavily unionized states, efforts at serving those individuals in their homes and communities continue to provoke very sharp responses from AFSCME and other related unions. So that's sort of the background, current controversy. To a large extent, disability rights forces won the earlier conflicts over deinstitutionalization. Home and community-based services now make up the overwhelming majority of state spending on residential disability services. Many, many more people receive services in their homes and communities than in state-operated institutions. And people with disabilities and their families now expect and demand that they not be forced into institutions to receive needed services. But those victories have set the stage for the current controversies. The workers who provide home and community-based supports to disabled people are part of what has been described as the fastest growing employment sector in the United States, the so-called home care sector. And according to Bureau of Labor Statistics projections, employment in that sector is expected to grow by nearly 50% in the decade leading up to 2022, a rate that's 5 times faster than employment in general is expected to rise. And wages for workers in this sector are extremely low. According to the National Employment Law Project, in 2013, the country's 2 million home care workers had average annual earnings of $18,598. So compare that to all wage and salary workers in the United States. Average earnings was about $46,000, $47,000. So this is a state of affairs that obviously raises serious moral concerns. Is it fair to treat any workers, and particularly those who do such important work, this way? Does such low pay for workers who provide home and community-based services limit the effectiveness of those services and thus compromise our nation's promise to the people with disabilities whom we have freed from unnecessary institutionalization? It also raises serious fiscal concerns, as many personal assistance workers depend on public assistance themselves to make ends meet. So this creates problems, but it also creates an organizing opportunity for unions. Jobs providing direct services to people with disabilities in their homes can't be sent to right-to-work states. They can't be outsourced overseas. And the workers who do these jobs have very legitimate complaints about their wages and working conditions. So although it was historically very difficult to organize workers who were so geographically separated from one another, right, working in individual homes, the SEIU and AFSCME developed techniques for doing so and placed a priority on it. And the increasing success of SEIU and AFSCME in organizing home services workers, I would argue, inevitably led to conflicts with disabled activists. The conflict focused on 2 big issues. The first was control. Who controls what a personal assistance worker does during work time? The second issue is money. How will increased wages for personal assistance workers in an age of limited resources affect the access of people with disabilities to their services? These conflicts, I would argue, have both drawn on and fed disability rights activists' long-standing distrust about the agenda of unions. So they also play out quite directly in legal and policy fights concerning the structure for unionizing attendant services workers. As SEIU and AFSCME proceeded with their efforts to unionize workers in this sector, disability rights activists understandably feared a loss of control. They feared in particular that unions would work out the terms and conditions of personal assistance employment with the state, which basically pays for all this through Medicaid, or with private home care agencies, and that would cut people with disabilities out of the process of determining both who would work for them and what those workers would do on a day-to-day and minute-to-minute basis to empower the independent choices of individuals with disabilities. After extensive organizing and negotiations, disability rights and labor groups eventually worked out a representation mechanism that would take account of the interests of both disabled persons and the workers who serve them. The workers would have the right to organize and bargain collectively with the state over dollars and cents aspects of work that the state controlled, because the state is the ultimate payer. But the individual clients with disabilities would retain the power to choose their own personal assistants and direct their work on a day-to-day and minute-to-minute basis. This reconciliation involved important concessions on both sides, and it wouldn't have occurred without long-standing and deep relationships between labor and disability rights activists, particularly in California where this model started, and the model soon spread to other states. But that model of representation ultimately got caught up in more general anti-union politics. From the union perspective, a crucial aspect of the California model was that it allowed all personal assistants providing a particular sort of services within the state's Medicaid program to join together in a single bargaining unit, and that the union would be empowered to both bargain with the state and collect a fair share or agency fee from all of the workers in the unit it represented. In Harris v. Quinn, a case the Supreme Court decided in 2014, right-to-work groups challenged the collection of agency fees under such arrangements. And when Harris got to the Supreme Court, this is one of the first places you see this conflict bubbling up recently, there was at least a bit of controversy within the disability community concerning what position disability rights activists should take. Collective bargaining limits managerial prerogatives, and in the case of attendant services, who are the managers? It's people with disabilities. And as a result, some people within the disability community favored the position of the anti-union groups. But many others took the view that disability rights activists should defend the compromise they'd so painstakingly worked out with the labor movement. And I actually represented a very broad array of disability rights groups from across the country, both nationally and in the affected states, who took that view. And we filed a brief in support of the union's position in the Supreme Court, but the court, in its decision, rejected our position, and we're still working out precisely what the fallout will be. This then ties into the other place where the conflicts are playing out, which is application of the Fair Labor Standards Act to personal assistance workers. So this is obviously a conflict about money. The more that standard wage and hour rules apply to personal assistance workers, the more expensive it'll be to hire them. But the conflict is also about control, because overtime protections may force individuals with disabilities to hire more personal assistants than they would prefer. Right? These are maybe individuals who have worked very hard to find somebody who works for them, who works well, who then are told, well, you can't have someone working for you for more than 40 hours a week. You have to find a second person, and they might find that very difficult. For years, exclusions in the Fair Labor Standards Act had been read to exempt most attendant services workers from the full protection of the statute. And unions and worker advocates had increasingly pressed to narrow those exclusions. In 2007, in the Koch case, it's hard for a law professor to pronounce it Coke and not Cook, although it's spelled like the drink. The Supreme Court held that the decision to narrow these exclusions was up to the Department of Labor. And when President Obama took office just after the Koch decision, using the Department of Labor's power to solve the problem was a major union priority. Well, it took the Department of Labor a long time to get around to it, but eventually they began to move on the issue, and when they did, they took steps that raised a special concern among disability rights advocates. The regulatory impact analysis that was submitted with the proposed rule, which is required to be submitted with all proposed regulations, blithely suggested that maybe a result of the new rules would be the reinstitutionalization of some people with disabilities, and that was a cost, but the cost was outweighed by the benefits to the workers. Well, so obviously that raised red flags for disability rights activists. And disability rights activists, led by the aggressive direct action of ADAPT, which is probably the most militant leading grassroots group of people with disabilities advocating for disability rights, protested the Department of Labor building, shutting down its entrances. They conducted blockades. They even protested at Secretary of Labor Tom Perez's house, stayed out in his driveway all night until he came out. They called the police. They wouldn't leave. These are folks who get arrested a lot in support of their protest activity. As I said, they sent lumps of coal to him in the mail. But that didn't deter the Department of Labor, which finalized its regulations, and a trade association of home care providers immediately filed suit. ADAPT, the National Council on Independent Living, and other disability rights organizations supported the lawsuit, challenging these new rules providing increased worker protections for personal assistance workers. And the lawsuit was successful in the district court in D.C. And on appeal to the D.C. Circuit, the American Association of Persons with Disabilities, a group made up of, by, and for people with disabilities, filed an amicus brief in support of the Department of Labor regulations. I was their counsel on that brief. That filing, just filing that brief, created a major conflict within the disability rights community, and indeed led to the spectacle of one disability rights group, ADAPT, organizing and protesting another disability rights group, AAPD. Spurred by that controversy and a lot of very frantic negotiations, the Secretary of Labor issued a letter that emphasized that states, which finance the bulk of attendant services for disabled persons, must implement the new rules in a way that protects rights guaranteed by the ADA. Now, the D.C. Circuit upheld the regulations. I was hoping that the Supreme Court would have addressed the cert petition by the time I talked today. We'll see on Monday what they do. But disability rights groups, both those who supported and those who opposed the regulation, are closely monitoring the implementation of the new regulation to make sure that it doesn't cause adverse effects to people with disabilities, but it remains a very sharp point of controversy within the disability rights community. So let me talk in a normative register for like the next 10 to 15 minutes and then leave this open for questions. So that's the background of the controversy. So let me offer a way of thinking about this controversy. So obviously, we would expect that interest groups will pursue their own particular ends in the political process, right? That's pluralism. Nothing to criticize about that. But it doesn't mean that a particular group's claims should be immune from normative assessment. And I think all the more so when the group is a social justice movement like the disability rights movement. The fundamental goals of the disability rights movement, most attractively understood, are not to elevate disabled persons above the non-disabled, but to achieve equal citizenship status. And when the claims of the disability rights movement bring that group into conflict with another social justice movement, such as the movement to empower workers, I think it's appropriate and necessary to engage in a normative evaluation of those claims that takes seriously the interests on both sides. So what I want to say is the normative claims of disability rights activists in the 70s and 80s were absolutely right in trumping the interests or in being favored over the interests of workers. But that once we get to the question of worker protections today, the normative stakes shift in important ways. Okay, so the normative argument for deinstitutionalization. When union groups opposed deinstitutionalization in the 70s and 80s, they defended their opposition based on concern for the welfare of individuals with disabilities. In those instances in which union groups oppose deinstitutionalization today, which still happens in some states, they tend to make the same arguments. And I think these arguments have been offered in good faith, notwithstanding the strong self-interest that unionized workers also have in opposing deinstitutionalization. As I described earlier, the opposition to deinstitutionalization, though, has largely been vanquished. Combination of civil liberties litigation, budgetary politics in the 70s and 80s, the ACLU-Ronald Reagan connection, aided by the adoption of the ADA in 1990 and the Supreme Court's 1999 Olmstead decision, not to mention developments professionally in the field, the continued refinement of successful models for providing community-based services and supports. All of this has turned American policy decisively against the institutionalization of individuals with disabilities, even as some pockets of resistance remain. And American policy has been right to turn against institutionalization. Disabled Americans are living better, freer, fuller lives. They're more centrally a part of the community, can more effectively enjoy full and equal citizenship when not forced to live apart from the rest of us in facilities limited to people with disabilities. As against the interests of hundreds of thousands of individuals with disabilities, and it was hundreds of thousands, living full lives as part of the community, the interests of workers in maintaining specific jobs in specific institutions should carry much less weight, I'd argue. If the choice were stark, a full life for people with disabilities or good jobs for workers who provide them services, and you can't have both, that would be a tragic choice. Even then, I'd be hard-pressed to say that the interests of a group of workers in good jobs outweighed the human cost of keeping a group of people in institutions. Fortunately, we don't face such a stark choice. Disabled persons don't need to be kept in institutional confinement in order to ensure that service workers have good jobs. The state can ensure that workers who provide community-based services are just as well compensated and treated as workers in institutions. And though Harris v. Quinn places some limitations on how a state can achieve this end, the state can also create structures to facilitate the organization of community service workers into unions that they select, and it can engage in collective bargaining with them still. The most visionary architects of deinstitutionalization, from disability rights activists to government officials to professionals to some union leaders themselves, have sought to structure community-based services in ways that seek to ensure that workers who provide those services have stable, well-paying jobs. That was the genesis of the arrangements that led to the Harris v. Quinn controversy. It's certainly, if it's possible to serve both the interests in disability inequality and worker protection, there's no reason to choose the latter over the former. And to choose the certain continued institutionalization of disabled persons to avoid the risk of weakening worker protections is not to accommodate the interests of people with disabilities and the workers who serve them. It's to sacrifice the interests of disabled persons entirely to those workers. That's not a sacrifice disability rights activists could ever be expected to endorse, nor would they endorse it. Of course, union leaders who opposed deinstitutionalization also offered an argument that was framed in terms of the interests of people with disabilities themselves. I've discussed that argument at length in other work. For today, let me just say three things. First, the evidence shows that on balance, deinstitutionalization has been far better for disabled persons than institutionalization, and that's true even when considering fully the real harms that some people have experienced after deinstitutionalization. Second, when harms have occurred after deinstitutionalization, they've resulted precisely from the failure to adequately invest in appropriate community-based services. We know how to serve people with even the most significant disabilities, whatever you think the most significant disabilities are, in their own homes in ways that promote full lives and equal membership in the community. That our governments have at times failed to put their money behind that knowledge is not an indictment of deinstitutionalization, but instead of that failure to invest. And finally, the third thing. Note that this argument, the argument that institutionalization is good for people with disabilities themselves, is the essence of paternalism. To tell disabled people you must live in segregation, but it's for your own good, is not to treat disabled people as equal citizens with an equal right to determine their own interests, and it's hardly surprising that the disability rights movement rejected that admonition and they were correct to. But what about today? The very success of the movement for deinstitutionalization means that today's iteration of the disability rights labor conflict has a very different normative stake. Where opposition to deinstitutionalization, period, places the interests of disabled persons in a subordinate position to those of the workers who provide them services, opposition to labor protections for those workers places the interests of disabled persons in a superordinate position. But both people with disabilities and the workers who serve them have important interests that a just society should take into account. Indeed, the very reason that deinstitutionalization did not present a tragic choice between the interests of these two groups was the prospect that workers who provide community-based services could receive adequate protections, and opposition to those protections would unnecessarily transform deinstitutionalization into a conflict between disabled persons and the workers who provide them services. So, the overwhelming trend is toward deinstitutionalization. The overwhelming majority of individuals with disabilities who receive services and supports receive them in the community. And there's no turning back that tide as a historical matter. It's just not going to happen regardless of what certain pockets of resistance will say. But disability rights activists legitimately fear that labor protections for the workers who provide community services will impede the move toward freedom and integration for people with disabilities. In the case of collective bargaining, as I suggested, the concern goes to the heart of the independent living philosophy that so much of the American disability rights movement has endorsed. That philosophy posits that the goal of disability rights advocacy is independence for people with disabilities, and independence, as I suggested, is defined not in the ability to perform tasks without help, but instead as the ability to make effective choices about how to live one's life. From the most major choices about how to construct one's life projects all the way to the most mundane day-to-day decisions. When to turn out the light at night, when to get a snack from the fridge, who to eat with. If a person can make these life choices big and small and make them stick, then she's independent in the sense that the disability rights movement uses the term, even if she has to rely on the assistance of others to put these choices into effect, by helping her get dressed for work, by physically fetching the snack from the refrigerator. And personal assistance services controlled by consumers are a central part of this. Collective bargaining by personal assistants threatens to upend that consumer control, but the choice is not nearly as stark as some activists suggest. The model of collective bargaining developed by disability rights activists in California and spreading to other states actually does a nice job of accommodating the key interests of both individuals with disabilities and their assistants. The model leaves control over day-to-day working conditions and hiring and firing with the disabled person, while it empowers the workers to band together to negotiate with the state over dollars and cents matters such as wages, which are matters that turn on state decisions. And given the availability of this accommodation of interest, opposition to collective bargaining has to rest on the determination that any interest of people with disabilities in controlling even the smallest increment must necessarily take priority over all interests of the workers who serve them. Just as when workers place their interests above those of disabled persons in opposition to deinstitutionalization, that's a position I would argue that has little to be said for it normatively. Now, the question over wage and hour protection obviously involves not just control but money, as I suggested. By granting attendant workers overtime pay rights, the Department of Labor's new regulations will either make personal assistance services more expensive or require some disabled individuals who had previously employed only one attendant to now employ two or more. To the extent that personal assistance becomes more expensive, people with disabilities and the state Medicaid programs that are often the ultimate payers will become less able to afford it. And the result will be that disabled people do not receive the services that are necessary for full and equal participation in the community. In many cases, an individual with a disability will be able to get by with less than full service coverage, but in others, the cutbacks may make the difference between the ability to stay in the community and effectively being forced to enter into an institution to receive necessary supports. And that, of course, was the point that the Department of Labor rather blithely mentioned in its regulatory impact analysis, and it's not surprising that disability rights activists would push back. But there's another side to the story. The workers who provide personal assistance services have the same interest in receiving fair pay and in having time for other commitments in their lives, their families, and their communities, as do all workers. The wage and hour protections of the Fair Labor Standards Act are the principal way that our society has chosen to protect workers' interests in fair pay and time away from work. Now, these protections have never reached all workers, and in part this is because of political compromises, like the exclusions of agricultural and domestic workers that were often driven by race and gender politics. But these compromises have therefore appropriately drawn great criticism. The maintenance of male domination of family economic life and of white supremacy in the Jim Crow South were key goals of those who pushed for these exclusions, and therefore it makes sense that we're questioning them now. As a normative matter, we ought not to make exceptions, I would argue, to Fair Labor Standards Act protections, except in two general circumstances. First, where there's good reason to think that a class of employees don't need the statute's wage and hour protections, as, for example, in the platonic ideal, if not the actuality of the statute's white-collar exemptions. And second, where there's something about the class of employment, whether about the job or about the people who are performing the job, that makes it economically unsustainable to provide full Fair Labor Standards Act protection. And there's some particular reason why it's important that this class of employment exist. So the overtime exemption for firefighters and small fire departments is kind of an example of this category, maybe. So many have sought to justify the minimum wage exemption actually for certain disabled workers in these terms, but disability rights advocates in recent years have aggressively urged that the exemption is not, in fact, justified, and they've had increasing success in persuading policymakers. Well, I would argue a similar rationale applies here. A similar kind of critique of the exemption applies here. An overtime exemption for personal assistance workers clearly doesn't fit the first category. Workers who provide attendant services are often poor. They often must work second jobs to feed their families. They often are members of disempowered minority and immigrant groups. And if anyone has a need for the wage and hour protections of the Fair Labor Standards Act, I think these workers have a very strong claim. I don't think the exemption fits the second category either. Granting the immense importance of personal assistance work to the independence or empowerment of people with disabilities, there's nothing economically unsustainable about providing full Fair Labor Standards Act protection to those who do that work. Because the money to pay personal assistants who serve disabled persons largely comes from the state, the basic question is one of political will. If we decide to invest in an adequate attendant services system, we can readily operate it while according workers their basic protections. Now, you might say that's idealistic. Okay, whatever. It's an academic lecture. It's idealistic. In the world we have, political pressures are conspiring to cut rather than invest in Medicaid. Disability rights activists can join with workers' activists to urge increased investments, but until that effort succeeds, some degree of conflict between the interests of people with disabilities and the workers who serve them may well be inevitable. But what I hope that I've shown in this talk, and I want to leave it open for questions, is that there's no good normative basis for preferring one side of this conflict over the other. For both disabled people and attendant services workers, define groups that experience some significant disadvantage and have a valid claim on social goods. And I would argue that the future of this conflict ought to be one of working harder to accommodate the important interests on both sides, rather than in simply fighting with each other over dividing up what seems like a shrinking pie. And that's my comments to you. I'm very interested in your questions. I know some of you have to leave at 1, so if I notice there are microphones traveling the room. If you have a question, please get a microphone and talk into the microphone. Thank you very much.
You've talked mostly about how, in general, it's Medicaid paying the tab. What about, and I don't know the empirical data on this, to what extent do you have private paying disabled people who are caught up in this, and do their interests play out any differently when they're taken into account in terms of both the collective bargaining part of it and the Fair Labor Standards part?
Yeah, I mean, so on the collective bargaining part, usually when you have privately paid attendant care services, what you have is like some agency that is the employer, and there have been efforts to organize those employers. That does happen. You often have quite less agency in a different sense in the consumer who's receiving the services. So that's sort of a target, a different kind of target, but an important target. And these home health care agencies that provide services are raising many of the same kinds of concerns about the overtime regulations for not surprising reasons. I mean, I think that gets to like the broader question of just America needs to have a much more realistic policy about long-term services and support. So we have this weird system that basically people bankrupt themselves to go into Medicaid, and Medicaid becomes our provider of last resort for nearly everyone, and all this work that goes on to kind of manage that. And I think you're going to have these very difficult situations. Often it's the more advantaged people who are privately paying, but often also it's only a very temporary way station before they go into Medicaid.
So just a very quick follow-up. So is the discussion any different, or are you including sort of elderly people? I guess would they count as disabled persons for this purpose?
Well, so this is a great question. So this dispute, I mean, so there's always a question in disability rights world of, well, why do we think of these as two separate groups? I mean, what requires greater services for people who are older is that people acquire disabilities as they age, and often the services are very similar. These disputes have really been focusing on more younger people with disabilities, but the services look very similar. You know, I think there is a difference often in what people want for their own lives, right? So people who have service needs as they grow older, you know, they may want to retire, so they're not looking to work. They're not looking to participate in the community in that way, although one of the trends we see as baby boomers age actually is they want to continue to be involved in the community in the same way. So I think the differences between these two groups are dissolving to some extent. Yes.
Yes. You'll know more about this than I do. In terms of care for the disabled, I've noticed that in some jurisdictions, at least, parents can be paid for taking care of their children. Mm-hmm. Is that in all jurisdictions under Medicare?
No, but it is in some jurisdictions.
Some.
And you know, obviously, you may have a question about that.
Well, I've noted that when I see testimony against organizing these workers, the parents are usually the most virulent against it.
Yeah.
And they seem glad to be paid for it, but they think it's ridiculous that they have to join a union to take care of their child. And I just wondered whether that would be an exception for you. Would you say that parents that are being paid by the state to take care of their own children could be an exception to both the Fair Labor Standards Act and collective bargaining?
Yeah, I mean, so I think that could be. I actually think that the parent issue is a really hard issue. I mean, one of the reasons why I think it's good to have worker protections here is, you know, the basic way we do a lot of these things is we provide it through Medicaid, but Medicaid doesn't provide enough. So home services under Medicaid are provided under a waiver. You know, you have an absolute right if you satisfy the relevant criteria to have nursing home care under Medicaid. But if you satisfy those criteria to get home services, you have to usually be on a waiting list because states get to cap the number of waiver slots they have. What that means is we often rely a lot on family members to provide these services, and what the move that has been made as policy matter is to say, okay, let's take some of that Medicaid waiver money and give some of it to the parents. We can pay parents less than we pay workers, so we can actually remove some burden on parents, get more services for less buck. And to some extent, that's great. I mean, you know, because parents and family members face these very severe limitations. On the other hand, there are a lot of individuals with disabilities who would actually prefer not to have their parents providing these services, right? And so one advantage of having a really fully resourced system of community-based services served by people who are treated as and paid as professionals is people who don't want their parents to be taking care of them. I mean, we're talking about adults with disabilities. You don't want your parents to be doing this for you all the time. So I do think you could – I think there's a case to be made for carving parents out of these worker protections, but I think it's also really important to have a robust system where that's not what people are forced to rely on.
You mentioned earlier on that some of the disabilities group activist groups were concerned that not having a right to work would sort of encourage the state to deal directly with a union and the union to only deal directly with the state and exclude disabled people from the discussion. Is there any evidence to the contrary that not having mandatory unions in certain fields would have the opposite effect? I'm a little bit skeptical that when the employers don't have to deal with a single bargaining entity, that they would somehow be more likely to include disabled people in the discussion and rather would just do the things they normally do in a right-to-work state and continue to exclude the disabled people from the discussion.
I think the question that these groups were sort of asking is who's the employer, and historically it had been the state or whoever the state is, an agency the state is paying that's the employer, and the consumer-directed model kind of moves a lot of the employer responsibilities to the individual with the disability, him or herself. And what these activist groups were responding to was not just collective bargaining itself, but thinking about the state as being the employer again, which they saw as kind of a retrogression. So employer power had gone to the individual consumer with a disability, and now it's going back to the state. And so it was really hard, actually, for a lot of groups to figure out how to reconcile what they understood to be important workers' interests with the idea that we've worked really hard to get control over who works for us, what they do for us. And actually, the important concession that unions made was at-will firing, right? There's no collective bargaining agreement in America except in this context that doesn't have a for-cause firing provision. But what these collective bargaining agreements said, and it was crucial to the model, was absolutely the individual with the disability has the absolute right to choose who is going to work for them and to discharge that person. Now, usually that person would go back on the list and be eligible to be hired by someone else. But that was a big deal, and that was the kind of thing that disability rights activists were afraid they'd lose if it went to collective bargaining with the state.
So I don't know all of the FLSA exemptions well, but my sense was that some of them were based not on a normative claim about the work, but on a practical argument about the nature of the work, that it doesn't fit very well into a 40-hour-a-week, 8-hour-a-day sort of model. I'm thinking of drivers and airline employees and people who work on ships where you just have to work at a different schedule than that by the nature of the work. Is there a practical argument for an exemption for people who provide in-home services, given the intimate nature of the work and the fact that at least for some people with disabilities, the care it's sort of round the clock, or people have to be on hand even all night in case something happens in the middle of the night. So, and I ask, not because I'm necessarily endorsing this view, but because it wouldn't be the kind of normative argument that you're talking about that places persons with disabilities above the needs of the workers, but just an acknowledgement that this is a kind of work that's different, is on a different time schedule than ordinary 40-hour-a-week workers.
I mean, so the problem is, the overnight thing you could deal with, right? I mean, that's not particularly difficult to deal with, but the problem is that it's not irregular work at all. I mean, it's very regular. So all the things you're talking about are irregular schedules. These are jobs with very regular schedules, and the problem is they're just jobs that often go on for way more than 40 hours a week. So no, I don't think it's a good case for an exemption. I think it may be a good case for saying when you're sleeping overnight, I mean, this is always the Fair Labor Standards Act kind of issue about how you deal with time when you're sort of on and sort of off, right? And there are different accommodations of that in different contexts. I think you could think about how to accommodate that part. But, for a lot of people, it really is just a very regular, very long work schedule, and it's hard to see why practically you couldn't just do it by the hour. And in fact, people do, when they have agencies they work for, they file their hours with the agency they're working for. So I don't see that practical distinction. I see a hand over there.
Hi, sorry, I came in a little bit late, so I might have missed this, but I was wondering if you could compare the wages between the home care workers and who used to work in the institutions, and if maybe there's a difference in those kinds of workers that might explain difference in wage.
Well, I mean, in some ways, I think maybe the difference in wage explains the difference in workers more than the other way around. So there is just the pay in the old institutions and in the institutions that still exist, the state institutions that still exist, does tend to be higher. It tends to be higher not because the work is necessarily different, but because it's part of public budgets, it is unionized, that has value, and I think when you have lower wages, then you attract workers who have fewer options. I mean, so another piece of this that I didn't have time to talk about today is when you have lower wages, what you end up with is a lot more turnover and a lot more difficulty in finding people who can do these jobs. There are people who will do them, but they'll leave as soon as they can find something else. And so there are pragmatic reasons as well for having higher wages. But I really think it's more the pull effect of the wages. So the wages are set kind of low, and then you get the labor pool you're going to get at those wages than the other way around. I see a follow-up.
So follow-up, my intuition is that the home care workers tend to be women. Maybe there's a result of less social value of care work that isn't institutionalized. And if maybe there's a Title VII claim or some kind of discrimination claim there to help bolster those wages.
So that's interesting. Probably because you have different employers, there's no actual Title VII claim, right? There would be no way to frame a claim as between similarly situated people. I think that the insight, though, that one reason why we do this, has to do with issues of gender and also race. I think that's absolutely right. So these are often women. It's often immigrants doing the job. It's pretty disempowered communities, and so it's not surprising that they haven't been able to kind of get a lot of force behind their claims in the political arena, at least until the shift about 20 years ago when unions led by SEIU started focusing on trying to organize groups like that, and that's one of the reasons you're seeing this conflict now. Wherever.
Okay. Yeah, I'm curious about you talked about waiting lists for people and how the gap between available funds and need is met. Is that in a diversity of ways by states? And do they prioritize based on how great the need is? And do some people get like part of the funding and then they have to come up with the rest with their private? Or is it really just, kind of first come, first served generally? And how big is the gap generally?
Yeah, so it's state by state. How big is the gap really varies by state. Of course, we don't totally know what the gap is because not everybody. There's a big population of people out there who are kind of scraping by without services, who aren't on a waiting list. So there are different ways of doing it, basically, and 50 states do it in maybe 50 different ways. But one thing that's pretty common is to have a series of different Medicaid waiver programs that provide different levels of services. So some people who get just like very minimal support, will rely on that. States can provide more of that. The waiting lists are often done with some kind of priority. Which actually leads to a lot of gaming of the priority system. So you can be put on the list, and really everybody knows you will never get services until you're in the priority category. So in Ohio, a case where I just worked with some advocates to file a lawsuit. They have something like 20,000 people on the list, waiting list for services, for community-based waiver services, and something like 10,000 of them are in a priority category. Maybe 8,000 are in a category where, they have an aging caregiver or they have some particular need that's not being met. Others just get on the waiting list because they know they're going to be in that category someday. So it's really, there's no one-size-fits-all answer, but there often is some kind of prioritization on it. And people find out. It's kind of like when you go to the emergency room, and if you're not going to be seen unless you say, "Oh my God, I think I'm having a heart attack," and then it turns out, well, I turned my knee, but they get mad at you, but they've seen you. So there's some of that happens with Medicaid waivers too.
Great. Please join me in thanking
Thanks very much.